Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Today's topic, heirs at law. What's an heirs at law? Did that sentence even make sense? So I have a client that's purchasing a property and the seller is the sole heir of her parents. So, her parents had owned property. One parent passed away 7 or 8 years ago, and the second parent passed away in 2020. And this person is the only child that's alive. There was in fact, she had a sibling. The sibling passed. Without children, never married. So our situation is that this person, the sole heir at law, is selling the property. Is that even possible? Does the person have to probate the will? Is there a will? So in this instance, there is no will. If there was a will, the title company would require that the will be probated in an effort to foreclose the possibility of any other heir coming forward and saying, hey, I'm entitled to a piece of the property. An heir at law is a way to sell the property without having a court proceeding. Now, the sticking block here, right, the event that could get in the way is whether or not my client, as the purchaser, is going to be given a title insurance policy, right? I realize as I'm answering this question, I could go deeper and deeper down the rabbit hole of explaining this or that. But the idea is that with a series of affidavits, sworn statements, and with a family tree, and a number of affidavits that will ultimately be required by the title company in an effort to give my client good insurable title, the seller of property can sometimes avoid a probate proceeding. If this is not clear, reach out to me. If you have an instance where you'd like to sell a property that was your parents', there are some instances where you don't have to go to probate. They're sort of few and far in between. If there were other assets, it wouldn't even make sense to try and sell the property like this. If there was a stock, bond, or brokerage account, or a bank account, if there was another reason, another need to go to probate, then the seller would just go to probate and get letters of administration, or go to an administration, right? Get letters of administration or letters of probate, whichever would be applicable, and then they'd sell. If you need to speak with me about real property and how it interacts with inheritance, go to my website, frankbrunolaw.com.